this is the basic, what you already know, that patents are the exclusive monopoly right granted for an invention to the inventor by the government. But these patent rights are granted on what? They are granted on your invention when it is fully disclosed in the form of a patent specification. So, there lies the crux, what to disclose, what not to disclose, how to claim, what not to claim, what should be written, what is the prior art, what is that thin line between the prior art and your invention. So, we will be discussing all these issues. Invention is specifically a solution for on a technology which was already there in the prior art, and there was some problem with this how to So, there was some problem with that particular technology, and our invention is solution of that problem which was there with the prior art. So, with what we will be dealing with the invention today, the disclosure of the invention in the specification, and these criteria should be fulfilled while applying for a patent in a patent office, that you already know, Anita must have told you. So, before drafting a patent specification, we should be very clear who would be dealing with our patent specification during the term of the patent. The term of the patent is 20 years from the grant of the patent, and before the grant of the patent, even the patent application is there in the patent office for approximately 4 to 5 years. That is the time frame according to the Indian Patent Act. So, approximately for 25 years, this patent document will be dealt by attorneys for anticipation, infringement, prosecutions, and judges who will be dealing with the infringements, patent examiners who will be dealing with the anticipation cases in case of whether the patent application is being anticipated by prior claiming or prior publication and all. So, what should be the language of your application, so that all these people, business people who see business in your invention, they should also be able to understand your invention, then only they will come to you and ask for your claims or your invention. So, it should be very well drafted for venture capitalist prospective licenses which you are looking for. Why are you inventing your technologies? Because you see some lucrative offers in terms of economy in that. So, this should be drafted in a manner that it should also invite prospective licenses, competitors in your area of research, and even for the researchers or the students who need your invention for further updation of the invention and to create new invention on your invention. So, it should be drafted while looking all these aspects. This Anita must have told you, but why I have put this slide in this is, normally people think that patent application, once it is filed with the patent office, it takes a very long time, approximately 4 to 5 years or 6 years, but it is not the case. In case your application is drafted in a manner, in such a manner that it does not invite any objection at 3 levels. This here the patent application, when it is open for the this, you know that the patent applications are being published in the official journal. So, they are open for pre-grant opposition. If this opposition is not there, then only the application goes further. So, if the application is being drafted so well that it does not have any pre-grant opposition, it does not have any objection from the examiner, even after the first examination report is being generated, you comply with those objections and your application comes in order of grant of patent, then immediately after that you are granted a patent grant which is open for post grant opposition for 1 year and then the letter of patent. So, I will tell you how to draft your application so that you can have your patent in a period of 8 months. It all lies here. You can have your patent within the period of 8 months. You first file with complete specification, immediately file for publication, early publication. I am sorry. Okay, it's not working. you file with the CS, then you file with the early publication. In early publication, you pay some fees which is required on the form 9, and then publication is done. So, this particular process will take approximately 1 month. Request for examination will take after 6 months. So, it will come to 7 months, and immediately if you apply for early examination, then within the time frame of 8 months you can have your grant of patent and you can avoid this rejection. But most of the patent applications are being rejected because they are wrongly drafted or not properly drafted, and most of the inventors are left with very few claims, and most of the cases only the principal claim is allowed, because they do not know what to claim out of their invention. They do not know what is their invention, where is the inventive step. So, this I am going to tell you. These are certain grounds of opposition which are under section 25, that patent is wrongfully obtained. These are the fraudulent cases, and prior publication in any document. We should avoid in our specification any such information, prior claiming, prior public use, obviousness, not an invention, insufficiency of description. It also becomes a ground for opposition. So, once your application is being opposed, then it will go for hearings between the examiners, assistant controllers, then the legal hassles will be there. So, it will get delayed once you establish your claim on your invention. So, we must avoid all these things by drafting our specification in such a manner that it should be very well foolproof. Now, this is the patent specification. It has got two features, the technical part and the legal part. Technical part is what the invention or the technical elements of a researcher or a scientist, they form the disclosure, and it is the technical part, and the claims which the inventor or the scientist claim on this disclosure becomes the legal part, on which most of the fights are there. So, and this disclosure, what to disclose, because we should take into consideration that after the expiry of the patent, after 20 years, this disclosure will be helpful for the society. It will become a useful art in the field of research. So, further improvement will be there and it will be helpful for the society. So, this disclosure should be well taken care of, and even the claims on the disclosure, so that you get both things. Normally what happens, most of the inventions, they are not prepared or they are not made in isolation. So, they are exposed to certain people or the society at various level during the final outcome of the invention. So, what happens before writing a patent specification, we should be very clear of having this document in our hand. This is called as Invention Disclosure form. In this form, we have one disclosure number which is confidential, and confidential between whom? Confidential between the people who were dealing with that particular invention at that particular time. So, we may have for one patent specification many invention disclosure forms. It is a kind of agreement between the inventor or a researcher and the masses or a public, through which the invention relates. So, it should have a conception of invention, which is the date of conception and first written description. They should be clearly mentioned on the deed of agreement. If these documents are lacking, then you may have any opposition, or you may have your competitor who can go to the patent office with your invention, slight modification, he can claim whole invention, even your invention he can claim in his invention. So, you must be very clear of having this document. The inventor name, at various stages the inventors changes. For example, in a lab, somebody, some researchers, they got transferred or they leave the lab. So, all those inventors name who are having knowledge, any kind of knowledge of your invention should be clearly mentioned. The proposed titles, the drawings if any at that particular stage. If there are no drawings, then it does not mention any information related to the invention. And in case of these pharmaceutical patents, when there is product testing and release. So, clear mention of the practice when this product has been launched for practice or launched for this testing. So, these information should be there. Has there been any disclosure or use of invention by the public? Answer should be there. Was there any use? Yes. this particular invention was used by such and such purpose at such and such time during that particular day, and it is being mentioned in particular logbook. So, all these details should be there. First internal disclosure and first outside disclosure. Internal means the persons who are dealing with the invention, like the true and the first inventors, they form the internal team, and the outer means outer to the public when it was first disclosed to the public, and all these should be under a non-disclosure agreement, a copy of which is to be attached with the specification while filing with the patent office, so that you do not invite any objection. In the research lab, this is the common problem. We go for publication before filing with the patent office. So, if you have done some publication, as madam was asking, have any articles been published? Yes, my article was published in such and such journal at such and such date. So, document should be attached. Details, any advertisement, press release, product announcements, attach a copy. Everything should be documented and witnessed by the witness, signed. Now, with all these documents, who needs to apply? True and the first inventor, or the legal assignee, or any other person who before his death was entitled to make such an application, assignee of that person, he can apply for the, where this Anita must have told you, there are 4 patent office depending on the jurisdiction. Now, these are certain formal requirements. One, we can apply only one application, that is on the form 1, and specifications are applied with form 2. And while filing with the patent office, the applicant should be in possession of the invention. Possession means, why possession is there? The legal attorney or the applicant or the true and the first inventor, if they are in possession, physical possession of the invention, then only they will be able to defend their invention during the course of grant of patent. If examiner wants some clarification over your invention, then only the applicant is allowed to talk to the examiner, or his legal representative is allowed, or the true and the first inventor. So, all these 3 people should have physical possession of the invention. It is required by the law, and this statement of undertaking of foreign filing is there. It should be filed within the period of 6 months of first filing of application in another patent office. So, this should be filed. Then proof of right to apply in case of applicant is different from the inventor. This also should be filed in case of applicant is different from the inventor, and these power of attorney, and you can file your this invention in the form of electric form. Then if nucleotides or amino acid sequences are required in your application, they are mentioned. So, all these sequences are to be provided in the electronic form to the examiner, so that the examiner, while examining the application, can have the best picture of your invention, what your invention is all about. This is the fee schedule, Anita must have told you. Now, this is our specification. We will be dealing on this. We will do one exercise after this to have a better picture of what to write. A patent specification is a technical as well as a legal document, and it can be filed in 2 ways, provisional as well as complete. Why provisional? To fix our priority, and in this we get 12 months for further research. You can perfect your invention, you can come again between the stipulated time of 12 months. We can disclose during this period, we can disclose our invention to persons to obtain some financial support. If we see that in our application, our invention has some potential in the market, so you can expose your invention during this particular time, because once filed the priority applications, you are not going to lose your claim, or you are not going to lose your novelty of your invention. So, we can do this exercise and we can see if there is some commercial feasibility. If it is not there, then we can avoid further expenses by not further filing with the complete specification. So, this can be done. What we write in provisional specification is the general nature of invention. We may not write specifically about all the experiments being conducted. We may anticipate our results, that with these experiments we may get these kind of results, we may get this product, we can anticipate all these things. We may not write claim, because there is no need of writing claims in this provisional specification, because the monopoly cannot be given on the claims in the provisional specification. We give a broader view of invention in this. In complete specification, we fully and particularly describe. Fully means whatever you have, the prior art, the prior knowledge the inventor is having, the invention the inventor is having, it should be fully described, and particularly word is for the inventive step. What you have which was not there in the prior art. They should fully and particularly describe the invention and method by which it is to be performed. It should be clearly defined. It should disclose the best method of performing the invention. There might be many methods of performing your invention. For example, your invention may work in a temperature range from 10 to 50 degrees Celsius, but your invention works best in temperature 30 to 40 degrees Celsius. So, what you can do, you can draft your application in such a manner, you can describe the application in such a manner that you have claim over the 10 to 50 degrees Celsius temperature. Though 10 to 30 and 40 to 50 degrees Celsius temperature was already there in the prior art, but you still can club whole prior art and you can have claim over it, you can have monopoly. You can say my invention is this, but you can have preferred embodiments in that the best method of performance was 30 to 40 degrees Celsius. So, it is the art of writing your application. चला गया वो सारा. I am not comfortable with this. हाँ, आप ऑपरेट कर दीजिए प्लीज़, मुझे सिर्फ वो पॉइंटर दे दीजिए. And the complete specification should end with claims which define the scope of invention. Scope of invention means the boundary which you have created. In that particular boundary, nobody can trespass. So, you must create your boundary in such, it should be a very strong boundary, so that others should not trespass. But you should know how to trespass into others' boundary. So, that is the line, like what I will be teaching you, to how to trespass into the others' boundary, how to claim the prior art, but you should prevent others from trespassing into your boundary. Claim shall relate to single invention. We may have many inventions in our invention, but we should draft it in such a manner that every invention looks like as if it is only one invention. We should claim in that particular fashion that we should fulfill this criteria of the patent office of single inventive concept. We can, during our hearing with the examiner, if examiner says no, these inventions cannot be granted, you file separate application for this. Separate application filing means you will lose your priority first. First you have filed with this invention, then you will file another invention, you will lose priority. You will lose your novelty, because your invention, you have a basic invention and then you have some preferred inventions. So, you will lose your novelty, you cannot file another, then you invite further expenses. So, to avoid all these things, you club everything in one invention with very nominal fees, you can have monopoly. Our main interest is in the monopoly, what we can claim. These are the content of specification. It should be in form 2, shall begin with the title. The rule says the title should not be more than 15 words. This is under rule 13.7, and the title should sufficiently indicate the subject matter to which the invention relates. Here every rule, every section is so important of the Patent Act that if we comply with these rules, then the examination cannot put any formal objection on your application, and you can reduce the time span of your patent application in the patent office. So, your title should sufficiently indicate the subject matter of your invention to which the invention relates. It should be accompanied by abstract. It is not more than 150 words. to provide the technical, technical information about what? It should have those particular technical elements to which your invention relates. Specific technical elements should be there. Why in the abstract? Because during publication, the 18-month publication, pre-grant publication, only the abstract is being published. Abstract, name of the inventor, address of the inventor, priority date, date of filing, all these things are there, or if any drawing or formula are there. So, we should clearly indicate what is in our abstract, the technical thing. Drawings if required shall be provided in complete specification. Model and sample only if controller asks for it or examiner asks for it during the examination of the application. And it should fully describe the operation, the use and the best method of performing. These are three features. Operation of your invention, when does your invention operates, in which condition it operates, this should be properly described. Actually, writing a patent specification is very much different from writing a paper. In paper, you write very specific things, but while writing this, you must disclose everything so that you can claim everything. And it should end with claims defining the scope of the invention. I told you abstract, it should have concise summary of specification, technical field of the specification, to which field your invention belongs, the technical problem and the technical solution. This is the only thing in the invention. So, these two things should be clearly described in simple terms, in simple language. No scientific language is required in this, because this application will be dealt by even by the lawyers, even by the researchers, even by the business people. So, it should have very simple language. If you write scientific language, then you cannot have maximum benefit out of your invention. Figures, if any, chemical formula and reference numerals with each feature, and it should not have more than 150 words. This is the criteria of writing a specification. First, it should be titled with the preamble. This feature is on the form 2, and the prior art which was already there, then what were the drawbacks, then efforts, what you made to remove those drawbacks, then you write the summary of invention. In fact, the specification is written under these titles, I can say. You must, yeah.
Madam, you are told that we should give most possible information in specifications. When somebody is going for prior art, for example, patent examiner is going for prior art.
Prior art search.
Prior art search. They will include all specification, or they will go only for the claims?
No. Examiner studies each and every word of the this invention or your specification.
No, not for mine. For example, I am an applicant. For my application, examiner will compare with the existing prior art. One way you are saying we should give more and more information. So, if we are giving more and more information, then to get inventive step, I think it will be difficult.
No.
At that time they are considering the claims of existing patents or overall information?
Overall information which has been disclosed in any other patent of application as complete specification, they see even that. Now, there are certain conditions which needs to be fulfilled. Description should state in clear and intelligent language about the invention, so that others may know about the monopoly. This is the trespassing which I was talking about of the patentee. So, this should be very much strong. They should disclose the manner in which the invention is to be performed, so that others may know how to repeat the invention when the patent expires. This is for the public at large. It should be repeatable, and how to carry out the new invention without doing further experimentation. That is why I was saying it should be in very simple English language. If some biological materials are required in your experiments, they need to be deposited to the International Depository Authority. India is signatory to Budapest Treaty. So, we have MTCC, everybody must be knowing, in Chandigarh. We have IDA. So, we must have from there name and address of the depository, date and number of the deposit of the material. And why do we need to deposit this material is, once we file our application and if someone sees an objection to your application in 18-month publication, pre-grant publication, then he can have access to the material in the depository by paying some fees. He can have a look whether this is objectionable or is to be opposed or what. So, this should be available to the public. The main motive of depositing your material is only that. Yeah. The drawings and figures, they should not be clubbed along with the specification. We must provide separate sheets for drawings and figures. They should not appear along with the text. Specification means the text, the written material is the specification. So, they should not appear along with the text. And we must provide at least one copy of the drawing on a durable paper. Why on durable paper? Because application will be there in the patent office for the whole patent term, 20 years. It will be maintained with the patent office. So, it should be on such a paper that it does not get rotten or gone away. इसलिए हो रहा है ये, एक मक्खी इतना काम कर रही है. हाँ हाँ, पेटेंटेबल हो गई ये तो, काम नहीं कर रहा इसीलिए. अभी भी नहीं कर रहा है तो. So what? Yeah. Wait. Yeah. Dimensions should not be marked on the drawings. All the dimensions should be mentioned in the complete specification and not on the sheet of the drawing, and drawing should be sequentially, systematically numbered. This means if there are 4 sheets and 4 drawings, then first sheet should be numbered 1/4, second 2/4, 3/4, like that it should be numbered, and there should not be any descriptive matter on the drawings. Next. The model or the samples when required by the examiner. We wish to have applications of diamonds. When we looked at this particular examiners can have access to samples, they can have access to models. So, we wish to have like those applications who are dealing in diamonds. Claims. Now, what to be claimed? The complete specification should end with claims defining the scope of invention for which the protection is claimed, and all claims should relate to single invention, or if there are many inventions, they should look like under the single inventive concept. They should be based only on the written description. That is why I was saying full disclosure, complete disclosure, so that you can have complete claim, the whole claims. Since the claim only defines the monopoly and no monopoly is given on the complete specification, description in the complete specification, one cannot have any claim. So, this monopoly is not given on the CS, so we should claim. If we file our application without claims, we cannot have a patent. So, these are must. The claims should not be extensive. If they will be expensive, if you write more in your claims, then what will you do? The wider claims will encroach upon the subject matter which is in public domain. So, your claim will be rejected, that it was already there in the prior art, now you are claiming, so it is rejected. Should not be narrow. Why it should not be narrow? Because it would not be sufficiently effective in preventing infringement of patent. If infringement of your patent, if you have claimed very less, and some other person has claimed a part of your invention in his application, then you won't be able to protect your right. So, they should not be very narrow. It would be against the interest of the applicant. They should be very specific, like words like maybe, likely, similarly, etc. they should be avoided, and in case invention comprises one or more embodiments, they must be specifically claimed. I will tell you how to claim these specific embodiments. When this complete specification is filed after provisional specification, we should investigate these 3 questions. Is the alleged invention broadly described? We cannot claim anything which was not there in the provisional specification. That mention should be there in the provisional specification. Is anything in the provisional specification which is inconsistent with the invention claimed? The claim and the provisional specification should be consistent. Does the claim include as a characteristic of the invention a feature as to which the PS is wholly silent? None of the claims should have any of the features which was not there in the provisional specification. Though the claims are made on the complete specification, but while claiming we must have a look whether we mentioned about these particular features in our provisional specification or not. If an inventor sometimes he does not write those particular embodiments while writing for a provisional specification, then he cannot claim even though these description was there in the complete specification. He cannot have a claim over those features. This is the structure of claim. We have normal three types of claims. Principal claim, which is the main claim. This main claim is verbatim of the statement of invention. We should have one statement of invention while writing a specification, and it should be verbatim of claim 1. It becomes the principal claim. If it is not verbatim, then it becomes a ground of rejection by the patent examiner. You cannot claim. Then the subordinate claims are the claims which have these preferred embodiments, like I was telling you about the temperature thing. So, those preferred embodiments should be claimed as subordinate claim, but these subordinate claims are dependent on the main claim, because main claim has the inventive feature, main claim has the novelty. Novelty and the inventive concept cannot be described in the subordinate claim. And then lastly, omnibus claim. These type of claims are not regarded, these are rejected. I claim to be inventor of, I claim a patent, no one else claim, the machine described is new. These type of sentences are disregarded. Claims on advantages, I claim that this device is better, cheaper, more efficient. I claim that my process or machine will do such and such things. You should avoid writing these sentences. The whole claim will be rejected. I claim the following advantages. We should have definite claims. The claims such as I claim an improved sewing machine as described or as illustrated. As described or as illustrated, these kind of words which merely refer back to the description. One needs to look back to the description. Then these type of claims are not required. Why these are not required is because when the invention goes to the market or to any venture capitalist for financial support or manufacturer, then only the claims are being sold and bought. The complete specification lies with the patent office. Because you have not claimed out of your specification, you cannot have any right on that. So, these type of claims if you write, then you will be losing your money. As described, what described? For this description, one needs to look into the specification, which is not allowed. So, you will lose this claim, no right over this claim. Nobody is going to buy this type of claim in the market. Or invention described, this described and illustrated words are avoided. Now, omnibus claim is the last claim when examiner rejects every claim, even your principal claim, your inventive concept, your novelty is gone, everything is gone. Then this claim comes to the rescue of the inventor or the applicant. If you have put this claim while first filing with the patent office in your first complete specification, then you can claim during the course of this examination course with the examiner. Actually, the applicant gets 12 months time, 12 months period to make the application in order of grant of the patent. So, onus lies on both the examiner as well as the inventor or the applicant to put the application in order of grant. So, both work on the application. So, if this claim is there and everything is gone, then the inventor can come up with a new claim based on, because he has already claimed the omnibus claim. Omnibus claim covers those features which were not there in the subordinate claim, not there in the principal claim, but these features might be described in the complete disclosure. That is why I was saying fully disclosure, complete disclosure with drawings, with everything, with chemical formula, model, sample, everything. So, if we put omnibus claim along with the complete disclosure, you can make new claims. You can say that, oh, my invention was not this, now my invention is this. And it will be acceptable only when you have described your invention in some of the figures, somewhere in the drawings, somewhere in your sample, then you can have claim. But if you have not put this omnibus claim, your application is lost. You can not make new claims. Once the principal claim or your novelty or inventive step is rejected under section 2J, you cannot amend your application. Now, this is for example, I have put this chemical formula. In claim, we claim like this, I claim or we claim. If one inventor, I, two, we claim. This is the preamble. The preamble portion of the claim is the prior art. We will take the prior art along with our novelty, our inventive step. So, how? Process for preparation of crystalline cimetidine wherein N-cyano, N-methyl, N2-mercaptoethyl guanidine is reacted with this chloromethyl 1-phenyl-methyl imidazole. These two are the reactants which were already there in the public domain. This reaction was there in prior use. You have also done this reaction. But where is your novelty? You characterize your novelty in the main claim or the principal claim. How? Characterized in that, this characterized in that word is required to claim. Here is your novelty, the reaction is carried out in water or in water containing medium at the pH range of 8 to 9.5. So, my novelty is very simple. This reaction was so complex, earlier people have done this reaction, but my novelty is where that I can perform this reaction in aqueous medium at this particular pH. I have only this much invention, but what my monopoly says, I will have monopoly over this reaction which was already there in the prior art, but along with my novelty, along with my invention. So, this becomes the principal claim. This is the gist of, and this is verbatim of the statement of invention. While writing your specification, under the column of statement of invention, you write this process for this invention is a process of this, wherein characterized in that these particular words they specify, characterized in that specifies that this is the novelty and this is the inventive step. This specifies that this is a preamble and this is the prior art. So, this is very clear. Now, process is claimed in claim 1. Now, this seems to be a very simple invention, but we can have 6 claims out of this. How? And every claim is so important. If someone wants to buy your invention, if someone is interested in this particular reaction, though it was already there in the prior art, he needs to buy all the 6 claims. You should write your invention in such a manner that not only the principal claim is important, you should put features in such a manner that each claim is important. The invention will not work without buying those particular claims. So, this is how you make your boundary strong and you trespass into others' boundaries. The process as claimed in characterized in that the reaction is carried out at pH range this. This is our preferred embodiment. Then the process as claimed in claim, which process? with this process. Characterized in that the reaction is carried out in inert atmosphere. This claim is silent about inert atmosphere, but my experiment works best at what? In inert atmosphere. And this inert atmosphere word came from when? From where? The complete specification. Somewhere in the specification it was written that though these are the series of reactions, I can work in this environment, I can work in this environment, but best performance was in inert atmosphere. So if you put this inert atmosphere in the main claim, then only one claim will be bought. You divide your application, you claim in such a manner that everything is important. That's why I told you fully disclose everything and then claim everything, but you write in a particular manner. These are not independent inventions, these are dependent on this invention. Only one invention, related, showing the unity of invention, different. Now examiner cannot say that these are different inventions. You are not mentioning about the inert atmosphere in this. If we would have said that process for preparation of this, the reaction is carried out in inert atmosphere. If we would not have said as claimed in claim 1, then it would have become the ground of objection by the examiner. Examiner would have said this is a separate invention, you file a separate application. But since we have made our invention as claimed in claim 1, we have made it dependent. So inert atmosphere is very important. Next, the temperature 0 to 5 degrees Celsius. It was also not there, but it is, my invention works best under these conditions. Then suspend equimolar amount of reactants. This particular feature was not mentioned. This is also very much important. My reaction won't work if the equimolar amount is not there of the reactants. So it has become important. Similarly, the pH of the reaction mixture is adjusted to the desired value by means of sodium hydroxide. Very simple thing. You can adjust pH with number of alkalis, but my invention works best when it is the pH is adjusted by sodium hydroxide. Very simple thing, but very important. So you should draft your application in such a manner that you can claim everything. This is the summary of what I told you, that you should compile your invention in the form of description, how to write everything. You write everything in a particular sequence. I gave you sequence. You write, incorporate search data and examples. Everything, every research data which you have come across should be incorporated in this, and you should describe your invention with the help of examples, with the help of drawings, figures, or draft claims carefully according to the requirement of the patent law. Now we will be doing one case law. You must be having that case study which I gave you. They are having foldable pen.
We have given the entire presentation.
Okay, yeah, it was there. ये फिर मक्खी बैठ गई इस पे. I have given you very simple invention, so that it should be clear how to write. It is a drafting of complete specification for an invention, a foldable pen. Simple, very simple invention, a foldable pen. This is the title. So title itself describes what the invention is all about. A pen which can be folded. Very simple. So we should write our application in such a manner. We should not write a pen having the shape of this, is made up of a plastic, a polycarbonate having these things. These things should be avoided. A foldable pen is the invention. This is the form 2, the complete specification under section 10, rule 13. Title is the foldable pen, and then applicant name should be the. हाँ वही कर रही है सारी प्रॉब्लम क्रिएट. Yeah. The address of the applicant and the nationality. If the applicant is not Indian, then you must, even if an Indian, then nationality has to be described. Then preamble. This is the preamble. We have two types of preambles. One for provisional specification, wherein we write the following specification merely describes the general nature of the invention. While filing for complete specification, the preamble should be this. This is the field of invention. The present invention relates to foldable pen which lies flat when it is not being used for writing and can be used as a bookmark when unfolded. So, our invention lies with this, that the pen which can be used both ways as a bookmark as well as a pen. When the pen is to be used for writing, it folds into a triangular prism so that it can be easily grasped by the hand. This is the field of invention. We should write an invention in such a manner that everything is clear. Everything is clear why we wanted this invention to happen, what is the inventive step, where is our novelty lies. Novelty lies in a pen, foldable pen which lies flat and can be used as bookmark, and it folds into a triangular prism. Then background, pens of the state of the art have barrel shape, this kind of shape, that kind of shape, but there were certain disadvantages. These should be particularly described. What were the disadvantages with earlier pens? So, these should be described. When a person is using a pen to make notes, it is uncommon for a person to use pen as a bookmark due to thickness, and if the book is closed, the pen is between the pages. Then when it is not possible to put writing such as advertising, we cannot put much of advertising on normal pens. In addition, due to their shapes, not too much writing can be printed on the barrel. So, what we are doing, what we are writing in disadvantages is what problem we are solving, how we solved the problem which was lying with the prior art. Then we write the summary of the invention, what our invention does, we write that. Then in the summary we write advantages of the prior art, how are advantages of the prior art, advantages of the invention over the prior art, and how our invention is useful over the prior art. We described completely. The one of the panels has a hollow reservoir for storing and dispensing ink with a pen tip such as the ballpoint tip or a felt tip extending into reservoir through which the ink will be dispensed. To use the pen as writing instrument, the outer edges of the two panels are pressed. How the invention is going to work, we need to describe everything. How to hold the pen, where is the ink, outer panel, hand until the outer edges of the two outer panels meet. Due to the hinges connecting the panels, a triangular prism results which is easy for the hand to grasp. While writing with the pen, the flat panel forming the barrel can be made of any suitable plastic or paper material such as polythene. Now, when we are describing our invention in such a manner, what we are looking at? We can have so many preferred embodiments while describing our invention. What are the preferred embodiments over here? Ballpoint tip or a felt tip. We can claim as subordinate claim either this tip or this tip, but my invention works best with felt tip. So, we can claim in subordinate claim. Then this suitable plastic material or paper material, this becomes the preferred embodiments while claiming our invention. Then we write statement of invention. I told you that it should be verbatim to claim one, a foldable pen comprising of flat body to form two longitudinal depressions in said body, a flat body of quadrilateral shape molded to form two longitudinal depressions in said body. Actually, while we are claiming, we have only one sentence per claim. So, we cannot put full stop in between, we cannot have more than one sentence per claim. So, we should write our invention in such a manner everything comes in the principal claim and the preferred embodiments can be further subsequently claimed in subordinate claims. To form two longitudinal depressions, set depressions acting as hinges defining three panels such that body may assume two distinct shapes, either flat or when folded prism. How a hollow reservoir located in out of the panels for storing and dispensing ink, a writing tip extended into the reservoir for dispensing the ink. Now, there is no mention of the felt tip, no felt tip, no ballpoint tip. We can have those embodiments as subordinate claim. Then we can describe it in detailed description, full disclosure of the invention with respect to figures. The figures are mentioned, the dimensions of the figures are mentioned, but the figures will be mentioned on a separate page. This is the complete disclosure. Now, this is the drawing, name of the applicant on the left hand side corner, sheet 1 of sheet 2, two drawings are there, two sheets are there, then applicant needs to sign over here. This is the second sheet. This person has described very clearly how this invention works, how the pen can be folded, and after folding the pen, how the pen looks like, what are the important dimensions which will be formed. So, what we can claim in here? A foldable pen, this is same as what was statement of invention. Yeah, a foldable pen as claimed in claim 1, wherein each of the panels is of the same size. This is preferred. If somebody makes the panel of different size, then this invention would not work in the same manner as my invention works. So, they should be of the same size. This same size word must have been there in the full disclosure of the invention. Then a foldable pen as claimed in claim 1, wherein each of the edges of each panel is beveled. A foldable pen as claimed in claim 2 or claim 3. This is dependent on claim 2 and claim 3, but claim 2 and claim 3 are dependent on the main claim, claim 1. So, it is also dependent on the claim 1, wherein each panel is tapered and folded, construction forms a truncated pyramid. A foldable pen as claimed in claim 1, wherein the panel having the hollow reservoir has a venting orifice opening to the hollow reservoir. We have not told about this opening in the main claim, where is the opening, where lies the tip, but we can claim over here. A foldable pen as claimed in claim 1, wherein the pen tip is a ballpoint tip, and also a foldable pen as claimed in claim 1, wherein pen tip is a felt tip. So, we can have two claims only on the tip. So, both have novelty as far as our invention is considered. This is the omnibus claim. The language of omnibus claim is such that a foldable pen substantially as herein described with reference to accompanying drawings. If all these claims are rejected, upper claims by the examiner, then when we have written that, we can claim something out of our drawings as herein described with reference to accompanying drawings. So, we can have something out of our drawings. We can make new claims seeing our drawings, whether novelty, some novelty is there. So, we can refer to our drawings while claiming. Yeah, that is all. Any questions over this? Yeah, yeah.
Suppose we filed a patent which is published.
Which is?
Already published the patent on methodology. Yes? On methodology you file a patent and it is published in the journal already.
Okay.
And then whether we can use that some of the method, some of the main aspects of that methodology in any of our published paper. Because patent still not granted.
patent is not granted.
But it is published, already published in the public domain.
Okay.
And whether we can use it, that some part of methodology.
You are asking about the publication in the journals.
Publication.
In the journals.
Yes.
Your invention is being published in the journals, and now you want to have a patent.
I have other way.
Hmm. You have applied for a patent. You have applied for a patent.
Then patent was published, but not yet granted. Okay.
Okay.
Now some of the,
You can do anything with your invention once filed with the patent office, because you have the priority or of novelty of your application or your invention.
So I can use.
You can anywhere. You can put it for advertisement. You can go for financial help. You can do anything with your invention, because you have a claim. You have a claim over your invention.
Okay.
Yeah. So
But
one.
Still not granted, but.
Yeah. Once it is filed, that date of filing becomes your claim over your patent from that particular date. So after that, it's only your claim if the patent is being granted. If the patent is being rejected during the course of time, then you cannot have your claim over your patent.
Yes,
Then it is in a public domain. Yeah.
That's obvious.
Yeah.
But
Yeah, it can be published, it can be advertised, yeah, it can be put into any
So
kind
that
of
is not
public domain.
illegal.
Yeah, that is not. Yeah.
From the very next day.
Yeah.
From the very next day you can.
You can, yeah.
But we tried because till 18 months it has not been published in the journal. So that is regarded as confidential. So it is better to publish after that.
Yeah.
But there is no, if you don't want to do that, even the next day
Yeah.
you can publish. So that because priority has already been established, there is no conflict.
Yeah.
A small clarification.
Yeah.
Ma'am Anita said if there is a publication, you have published before going to the patent, you have published your article, and then it becomes a prior art.
Yes.
So that is what we've been told.
Yeah.
And then there is a chances that it may be rejected also.
Yes. You can kill even your novelty. The same invention can kill the novelty of the patent document.
That
Yeah.
is our stance.
Yeah. That comes into the public domain.
Like by disclosing it or doing
Yeah,
that,
but it can be saved. I told you by the invention disclosure form. You can save your invention. You make a deed of agreement with the journal that I am going to file my patent application with this invention which is being published in your journal. You can have that non-disclosure agreement. If you have that deed of agreement, you can submit with your application, and then it can be considered, because then it becomes a legal document. Yeah. Yeah.
In some institute, if someone produces some new thing, I think, for example, we take a squash.
Okay.
The scientist put his document on the e-news of their own institute. Will there be a legal patent after that?
No, you cannot, because it is in the public domain.
Okay.
Yeah.
And there is another one difference. Suppose in the patent document you are giving the specification of your research. Suppose you have given the thing, but you have not disclosed your proprietary, but for the purpose, just like the technology open, okay, this is the technology, but you have not disclosed your invention. That much you can do, but publication should be done after that. And another part is that you are definitely, when some funding agency is giving you, so you are submitting the report to them. That will not be covered under that public domain, because these are the limited copies and the limited people report. But a wider circulated email will be treated as
Yeah, as in public domain. Yeah, prior art.
Most of our research will be coming in the annual report of the institute and all.
But in that case, you should not give your proprietary information,
Annual-
which you are going to claim.
Yeah.
Because the annual report will be widely circulated.
But it will not be covered in the prior art, no?
It will be covered.
It will be covered.
It will be covered. Yeah.
If anybody infringes that,
Yeah.
so in that
It's-
case, they can show that it was already been published
Yeah.
in your annual.
It's better you write your annual report or your research paper in such a manner that you take out your inventive step out of that, and then you can have claim over your prior art and your inventive step, you combine both and file with the patent office.
And one more thing, ma'am.
Yeah.
In these 2 days, we have come to the conclusion that drafting is much more important.
Yeah, it's very important, I told you.
The only thing, just one, ma'am, where all we can get this already, which one has been, patent has been issued, are they available on the public?
Yeah,
domain?
they are.
Drafts are available.
Yeah. You can see the whole patent application, yeah, at the websites of various patent offices worldwide, as well as certain databases are there, NRDC,
Any
NIC.
other site you must have come across where few good drafting things have been given on the patent?
You should look for the websites of the patent office directly, USPTO, JPO, Indian patent offices. You look on those sites and you will have a better picture. Like this invention I told you, this is a specimen. I have taken it from those websites only.
So here we will be having the practical session on the prior art search. In this case, you will be knowing that these are the patent databases and how you are going to extract the application notes. We will be having the practical exercises. And today, madam has given an overview that how important it is and what precaution we should have while drafting the patent application. But we will be doing the drafting exercises. Yes.
Whatever you are doing for the first time, that cannot be claimed as a patent. Suppose some technologies which are there in rice and wheat and all those things, you are trying it on a novel crop. That goes only as a first time attempt. No?
First time on that particular crop. It was there in other crops.
Other crops.
But it is very obvious for a person who is working in your field.
Yes.
Then it becomes the ground for, yeah, it cannot be patented. Then there is no inventive step in that. Yeah.
No, maybe for your crop you made some modifications.
No.
It is inventive step.
For that particular modification, that particular small thing, that modification along with the prior art, you can claim. That's what I told you. Everything is there in the prior art, but you have a very small line is there, cellular line is there between the prior art and your invention. You should know how to grab that prior art in your claim.
And you are applying the same thing in the different crops. So maybe you are modifying some conditions. Temperatures are different, pH is different.
Very small things, very small things.
The biology of the crop.
Exactly. So then it is a novel step.
That is a novel.
Then your invention is not in that crop, not in that technology. Your invention is in that pH, in that temperature. Yeah.